Welcome to today's webinar, which is on how JobWatch can help people experiencing employment law issues. I'm Carly Hanson. I'm the Sector Development Officer at Community Legal Centres Queensland. And before we get started, I would like to acknowledge the traditional owners of the land on which we're holding today's webinar. In Brisbane, they're the Turrbal and the Yagara people. I wish to pay my respects to their elders, past, present and emerging, and acknowledge the important role of Aboriginal and Torres Strait Islanders in our society. As this webinar is being viewed by people throughout Queensland and Australia, and we've got presenters presenting today from Victoria, I'd also like to pay my respects to the traditional owners of the land throughout the country and extend a really warm welcome to any First Australians who are listening in today. So we're joined today by Ian Scott, the Principal Lawyer at JobWatch, and Zana Blytheway, who is the Executive Director there. They'll be talking to us today about JobWatch and the work that they do, particularly around providing assistance to employees about their rights at work. So Zana and Ian will discuss some of the major areas of employment law and the most common queries received at their centre, including unfair dismissal, bullying, general protections, redundancy and underpayment. JobWatch, while based in Victoria, does provide services to Queensland, which is why we're holding this webinar. So I've sent out the PowerPoints this morning to everyone who had registered as at about 11 o'clock. I've also uploaded those to the handout section of the GoToWebinar control panel, so you can download those if you need to. As per usual, we will hold questions over to the end. There is quite a lot of content to get through, but if you do have any questions and need to head off, please type them into the box early and we'll address those and keep them in the recording so you can access those later if you need to. We're recording today's webinar and we'll put that up on our website probably tomorrow. And just a reminder that we will have questions at the end, so you can ask questions by pressing the button that looks like a hand, and we'll see those hands come up and we can unmute you if you've got a microphone, or you can just type those into the question box and we'll read them out. So I might now hand over to Zana, who I think is kicking this session off, and I'll let Zana and Ian introduce themselves a little further. So thanks guys, take it away.
Thanks so much, Carly. It is such a pleasure to be doing this webinar for Queenslanders. We're very excited about it. So, yes, my name is Zana, by the way, and I'm the Executive Director of JobWatch, and I am joined by my extremely knowledgeable and experienced Principal Lawyer, Ian Scott. As I said, we're very pleased to be presenting this webinar. Now, we've got a lot of content to cover, and we'll obviously do our best to cover it. But in the event that we don't get through the content, rest assured you have very comprehensive PowerPoint notes there that are available online, and Carly's indicated that you have access to that. So, and as Carly's indicated also, there'll be a Q&A available at the conclusion as well. Now, just a bit about JobWatch. So, JobWatch is a Victorian-based service, and basically we were established in 1980, and we are an employment rights legal centre which provides assistance to workers regarding their rights at work. So in essence, our core and most used facility is our free confidential telephone information and referral services, which are now available for Queensland workers. We also provide community legal education through a wide range of resources. Self-representation assistance is also available through our unfair dismissal self-representation kit, and also the Making a Small Claim under the Fair Work Act kit. There's a terrific JobWatch employment rights information app, which is basically an interactive, and that's been widely utilised as well. The JobWatch Telephone Information Service, otherwise known as TIS, It does provide tailored legal information and practical assistance to the callers, obviously in relation to their work. And when I say tailored, it means that when someone calls, their circumstances are taken into account before the legal information and practical assistance is provided. The areas that we provide assistance in include unfair dismissal and general protections, redundancy, that's where you've been made redundant, or if it involves unpaid wages, superannuation and other unpaid entitlements, workplace bullying, unfortunately, sexual harassment, parental leave, discrimination in the workplace, and also enterprise agreements, modern awards and employment contracts. I will take this opportunity to give you the Queensland JobWatch telephone line, just as a reminder to everybody that the service is available, 1800 331 617. JobWatch was extremely fortunate that in January last year, 2017, our partners, the Fair Work Ombudsman, provided us with funding to assist Queensland workers. So over that 2017 calendar year, JobWatch is pleased to report that it has received approximately 3,000 calls from Queensland workers, which represents about 25% of all calls to the service. Now, we see this as just the tip of the iceberg because this is such a new service, and yet we have hit the ground running. So as word spreads of the free and confidential nature of the service, obviously these figures will grow. I'll take this opportunity to ask all in the room and all participants to basically inform your friends, family, colleagues of the service and remind them that they can actually utilise it. Okay, I think Carly has basically advised of some of the areas that we'll cover, but just another reminder: bullying and discrimination, unfair dismissal, the very complex area of constructive dismissal, general protections, underpayment, sexual harassment, and if we have time, if we do have time, the gig economy, of course, and there'll be the Q&A. I just want to ask that anybody in this space, if you've got a particular area of focus or something that you want us to cover particularly other than those areas mentioned or any particular aspect of those areas, please make sure that you text in that focus and we'll try and stick to that, to your request. Thank you. The next aspect is just a bit of housekeeping. It's a disclaimer. Just a reminder that this is not legal advice. This presentation does not constitute legal advice and is designed for national system employees, that is, employees other than Queensland state public sector or local government employees. All very technical, I know, but has to be said. Okay, I'm going to cover off on the topic of bullying, and then I'm going to hand over to Ian to provide the remainder of the presentation. We put bullying down as our first area to cover because over the 2017 calendar year, we received approximately 300 calls relating to workplace bullying from Queensland workers alone. I think this is a sure indication, unfortunately, that bullying is rife in workplaces and is a serious problem that needs to be addressed. And what better way to address it than firstly understanding what your rights are in respect to workplace bullying. Excuse me if I'm shuffling a couple of papers here. Okay, so what constitutes workplace bullying? So under the Fair Work Act, the national legislation, workplace bullying occurs when an individual or group of individuals repeatedly behaves unreasonably towards a worker or group of workers and the behaviour creates a risk to health and safety. So that's the key aspect of it. Can I remind you, though, that an exemption or what's not included here, reasonable management action carried out in a reasonable manner will not constitute bullying. Okay, at the state level, meaning under the Work Health and Safety Act Queensland, the Workplace Health and Safety Queensland can deal with bullying, workplace harassment, where a person is at risk of injury or illness from bullying, which is defined in that piece of legislation pretty much the same, but as repeated and unreasonable behaviour directed towards a worker or a group of workers that creates a risk to health and safety. So the real emphasis here, risk to health and safety, which can of course include psychological and physical risk. The repeated behaviour refers to the persistent nature of the behaviour and can involve a range of behaviours over time. Unreasonable behaviour means behaviour that a reasonable person, having regard to all the circumstances would see as unreasonable, including behaviour that is victimising, humiliating, intimidating or threatening. So workplace bullying may include, and you'll see that up on the PowerPoint, and I'll just touch upon a couple of them, the rest you can read, but it constitutes scenarios including insulting, abusive or offensive language, inappropriate comments about a person's appearance or lifestyle, and of course physical assaults or threats. It does not, though, constitute, as I previously mentioned, reasonable management actions carried out in a reasonable way. It does not constitute allocating work to a worker or setting performance goals or standards or deadlines. So, what are some proactive steps prior to legal action? Like everything in life, we must explore the other options available to us before we embark upon legal action, which of course is time-consuming, extremely stressful and costly, yes. So basically, one of the first things to do is that if it's safe to do so, and I emphasise this because if your bully is someone who it's entirely unpredictable, obviously you don't want to approach them, but if it's safe to do so, a worker can tell the bullying that their behaviour is unreasonable, that it's inappropriate and that they want it stopped. So that's the first course of action. Don't forget to seek support and advice. Most workplaces have an OH&S representative. A worker should also seek professional counselling or see their GP in respect of the bullying. One of the most significant things is to keep a diary. Record the bullying incidents, the nature, the time, the date, any witnesses that may be available, so that you've got a clean record of it, because in that state of stress, it's so easy to forget what occurred, and accuracy is all important when it comes to evidence. You can, of course, report the incident, and you can also activate the dispute resolution procedures, which may in fact be available through your enterprise agreement. The other important thing is to speak to someone obviously that you can trust. It can be someone within the workplace, perhaps a manager or supervisor that you get on well with, union member, co-worker, and also don't forget your external sources that you can rely upon if you feel that you can share this with your family. Don't forget, of course, that sometimes taking these steps could lead to a dismissal, which may then trigger an unfair dismissal claim. Okay, so if having approached the relevant person hasn't worked and other avenues have been exhausted, you then you turn to the legal options available. And of course, you need to consider a police complaint if that is applicable. You can most significantly apply to the Fair Work Commission for an order to stop bullying. This is an incredibly effective mechanism. Now, in order to be eligible to make an application for the order, the worker must still be working at the business or organisation that they are being bullied. This is self-evident because obviously if they've left the workplace, resigned, or their employment's terminated, then the bullying by its very nature ceases. A stop bullying order can also be obtained against other workplace participants, meaning those who are not necessarily employed by the applicant's employer. However, a stop bullying order can only be made where the person is working at a constitutionally covered business. So that's the technical aspect of it. The Fair Work Commission can make any orders it considers appropriate, which is really very good, to stop the bullying. But no financial remedy is available unless a stop bullying order is contravened, which of course is a civil remedy provision. And in those circumstances, an employer can be fined up to $63,000 for a company and $12,600 for an individual. And this is usually payable as consolidated revenue, but the applicant can ask for it to be paid to them. Now, the really good thing about this, because obviously the whole idea about the stop bullying order is to stop the bullying, and the Fair Work Commission must in fact start dealing with it, with the application, within 14 days. And that's usually done by way of conciliation to see whether the matter can be resolved by agreement. The other option available, the other legal option, is the Work Health and Safety Queensland complaint. Employers can be fined, and I think the highest penalty being $3 million for a Category 1 offence such as industrial manslaughter. So very serious consequences, of course, and then the penalty being severe as well, as it ought to be. The requirements for this are that the complaint must be or fall within the definition of workplace bullying, of course. It must be in writing unless there are exceptional circumstances. And the complainant must contact the Work Health and Safety info line for an information package. And that's also a prerequisite. And attempts also should be made to resolve the situation within the workplace prior to contacting the Work and Healthy Safety Queensland. Okay, some other options involve a workers' injury compensation claim. So an employee who suffers a work-related injury as a consequence of the workplace bullying may be able to make a claim, and this may result in compensation, often involving a percentage of the pre-injury earnings, medical expenses and any counselling costs. There's Comcare claim, which is similar to the above but for Commonwealth employees. And it's really worthwhile to note right here and now that these three claims can be made at the same time, as they do actually constitute different claims or different causes of action, and the outcomes sought, of course, are different. So in these circumstances, I think Ian advises that the three claims are made at the same time in relation to the workplace bullying. Okay. So the Fair Work Commission's stop bullying orders have included orders that individual parties specifically not make contact with each other, makes really good sense, and that they can only contact each other via email during specific times, that they do not attend certain premises, and that they do not denigrate or humiliate one another and behave in a way that is reasonable and professional towards each other. All, of course, common sense orders to be made. In respect of companies, the orders that can be made include providing all staff with anti-bullying training and to conduct training for all employees on appropriate standards of behaviour in the workplace. Now, this is a recent case, and Ian thought he would highlight this to be able to explain how it can be used in a way to get an interim order so that it prevents the stop bullying order from being usurped, basically. So this is a fairly interesting case of Lynette Bailey and recent. So the Fair Work Commission granted its first interim order issued in its anti-bullying jurisdiction, which effectively issued an injunction to stop an employer from proceeding with a workplace investigation. The orders prevented the employer from continuing a process which might result in the termination of the employment and, of course, then defeat her stop bullying application. So, as I said, it's a very interesting case. So Ms. Bailey filed an application alleging that various senior executives and co-workers were engaging in bullying behaviour, and she was seeking preventive orders. Ms. Bailey accused her employer, the Bendigo Kangan Institute, of victimising her by making allegations of misconduct and launching a formal investigation after she had complained about another employee. The employer, of course, denied the allegations and said that their actions were reasonable management action and therefore did not constitute bullying. So Ms. Bailey applied for an interim order to stop the investigation and to prevent the Institute taking any disciplinary action against her, and until, of course, her anti-bullying application had been determined. This, of course, would force the employer to stop the process, allow her employment to continue in the normal course, and would not obviously dismiss her. So, as an interim measure only, and of course without making any final determination on the facts of the matter, the Commissioner found that Ms. Bailey's application had a significant or a likelihood of success to justify the interim order, preserving the status quo until, of course, the case could be fully heard. So that's really important. So basically the employer was trying to put an end to the stop bullying order by putting an end to her employment. So the very thing that we said at the start, that if you're not there, then of course the bullying order, stop bullying order, can't apply. Okay, so we're on to the significant and interesting area of bullying and discrimination. This is really fascinating because you've got, remember, the stop bullying order, and so bullying per se, the prevention of it, but it also may be unlawful under the Anti-Discrimination Act of Queensland. So if bullying is engaged in because of a protected attribute, and they are listed there for you so you can read them yourself, but for example, if you're bullying someone because of their sex, or if you're bullying someone because of their relationship status or pregnancy, then there may be a claim in respect of that. So the discrimination claims that could potentially be made are the same as in any other area. There is the direct discrimination complaint and also the indirect one. So in the Queensland jurisdiction, direct discrimination, as it applies in every other jurisdiction as well, happens when you're dealt with unfairly on the basis of one of these protected attributes listed earlier, specifically obviously in this area of employment, and it includes contractors. Indirect discrimination, however, is highly technical and is a different beast altogether, but it applies in circumstances where sometimes a policy, a rule or a practice seems fair because it applies to everyone equally, but on closer examination it shows that some people are actually being treated unfairly. This is because some people or a group of people are unable or less able to comply with the rule, or are disadvantaged because of it, or because of their prohibited attribute. If this policy or practice is not reasonable, it may in fact be indirect discrimination. Now, a really important thing to remember in relation to discrimination is that you can make a claim against the person that has discriminated against you, but additionally, you may be able to make a claim against the employer, that is the organisation that in fact employs the two of you. So this is basically referred to as vicarious liability, and it is a circumstance where the employer or principal is actually responsible for the work or agents while they are on the job. So if these actions are found to be unlawful under the Queensland Act, both the person complained about and their employer or principal may in fact be held responsible. This is really important because sometimes the co-worker may be an empty vessel with hardly any funds, whereas of course the employer, we know, is pecunious, and therefore a claim can be made against the employer. The defence the employer may have is that they need to show that they've taken reasonable steps and to prevent the behaviour in order to avoid their vicarious liability. And that may include, those reasonable steps may include that they have policies in place to prevent such behaviour, and additionally that they've trained their staff in respect of those policies, and there's awareness in the workplace about it. Okay, so in these circumstances, what are the legal options available? Now, noticeably, the word bullying is not used in anti-discrimination legislation, so that's important to note. But of course, once again, remember it has to be associated with the protected attribute. So if the matter is not resolved at the, so you can go to the Anti-Discrimination Commission in Queensland, which deals with such complaints, and you have 12 months to file your complaint from the date of the discrimination. And if the matter is not resolved, the first port of call is conciliation. If the matter is not resolved at conciliation, the matter could be referred to the Queensland Industrial Relations Commission, where it is solely employment-based discrimination that is heard. So they only hear employment-based discrimination matters. Otherwise, the Queensland Civil and Administrative Tribunal, you can go there, which actually hears a mix of employment and non-employment related discrimination. Now, in these circumstances, what are the remedies that are available? So the principal remedy is damages, and that usually relates to economic loss. It can include pain and suffering, and there are a host of other orders, including public apologies, anti-discrimination training, etc., all very useful tools by way of a remedy. So who is protected at work? The prohibitions under the Anti-Discrimination Act prohibits discrimination within the workplace. And so work is defined within the schedule to include not only permanent and casual and temporary employees, but also work under a contract for services, that is contractors. That is really important to know in an environment where there is a great push for employers to argue that an employee is in fact a contractor to avoid their obligations, but in these circumstances they cannot do so because contractors are protected as well. They also include work remunerated in whole or in part on a commission basis, work under a work experience arrangement, work under a vocational placement, work on a voluntary or unpaid basis, so it encompasses volunteers, and work under a guidance program, an apprenticeship training program, or other occupational training or retraining program. So hence you can see that it's a wide range of workers that are protected. Okay, alternatively, if an employee is the target of workplace bullying because of a federally protected ground, most of them overlap, but not all of them, then within 6 months from the date of discrimination, a person can lodge a complaint with the Australian Human Rights Commission, and the Commission is then able to conduct a conciliation conference, and fortunately attendance at the conference is compulsory. If you want to guarantee conciliation, you now have to file within 6 months. Otherwise, the Commission can just refer the matter straight to the Federal Court, and the applicant may then need to obtain leave of the court to proceed. So you don't want to be put in that particular jurisdiction. So the jurisdiction of the Australian Human Rights Commission, of course, federally, there is the Race, Age, Sex and Disability Discrimination Acts, and pretty much akin to you know, our state legislation. Of course, the Australian Human Rights Commission can investigate and resolve complaints of discrimination, harassment and bullying based on a person's sex, pregnancy, marital or relationship status, etc. Federally, there is a similar test for discrimination, being direct and indirect, and employers also can be vicariously liable, but we won't sort of go into that in any great depth at the moment. Also, at this point in time, we won't talk about exemptions and exceptions to discrimination because, once again, we have limited time. The protected grounds federally and the protected attributes at state level may differ, so be careful about the jurisdiction you choose. This is the greatest challenge when we have our clients coming in. What is the best jurisdiction? Which conciliation process is the most effective? And what is the outcome? And particularly, obviously, costs following the event is an important consideration. So basically, costs do follow the event in the Federal Court and the Federal Circuit Court, meaning if the claim is unsuccessful, the applicant will have to contribute to the respondent employer's legal costs. So a huge, huge consideration if you're considering pursuing a federal jurisdiction claim. Being bullied because of a protected attribute would likely be direct discrimination as opposed to indirect, which occurs where a person, as we've indicated earlier, is treated less favourably because of one of the protected attributes. Also, there's no requirement for the bullying conduct to be repeated. This is really important. Example, one racist joke may be sufficient to amount to unlawful discrimination. Also, to be eligible to make a complaint of discrimination at the Australian Human Rights Commission or the ADCQ, the person does not have to be a national system employee or work for a constitutionally covered business. That is also significant to note. It should also be noted that under the Australian Human Rights Commission Act, a person can't file at the Commission if a claim has already been commenced at the state level. So once again, choosing your jurisdiction, state or federal, is essential. Now we've got a few cases there that are already on the slideshow, which where that it was proved that there was unlawful discrimination. I'll leave those to you to be able to digest and read for yourselves. It makes for interesting reading. One of our JobWatch case studies is really pertinent, and this is really important because this is the nature of the calls that we get on the service. This call said, I have faced bullying and harassment from my manager over the past 12 months. I put in a grievance complaint, went through an internal process, but was extremely disappointed that the investigation did not call on witnesses. When my complaint was dismissed, I was issued with a formal warning for being late multiple times, which our caller says wasn't true, and the caller did not want to return to work. So just to give you a little bit of a snapshot, and there's more of those, to give you an idea of the nature of our calls. I'm very conscious of the time, and we've got a lot of content to go through. I will finish up here and hand over to my principal lawyer, Ian Scott. Don't forget any focus that you that you want us, I can just see some of these, sexual harassment. So we'll look into that as well. But I'll hand you over to Ian, and thank you very much for participating in the webinar. I hope that you find the webinar and our PowerPoint useful.
Thank you very much, Sana. That was great. That's a hard act to follow. All right, moving on to unfair dismissal now. What is unfair dismissal? An unfair dismissal is a claim a person's dismissal from employment was harsh, unjust, unreasonable, not consistent with the Small Business Code, if applicable, and not a case of genuine redundancy. If eligible, and I'll talk about eligibility in a minute, a dismissed employee only has 21 days from the date their dismissal took effect to file an unfair dismissal claim at the Fair Work Commission. Once filed, the Fair Work Commission will hold a voluntary telephone conciliation. Usually comes on within 3 to 5 weeks of filing. Approximately 80% of matters settle at this stage for around about 6 to 8 weeks pay, plus other items such as a reference or a statement of service, the right to retrospectively resign, and any other non-monetary things that might be negotiated. So that's the good thing about conciliation and unfair dismissal. Just about anything can be agreed, e.g. return of property, apologies or statements of regret, and other loose ends can be sorted out, like underpayment of wages or paying lieu of notice at that stage. If the matter is not settled, it will be listed for hearing in about 3 or 4 months' time, and the remedies at hearing are very limited, which I'll explain in a little bit. All right, so in considering what is harsh, unjust or unreasonable, the Fair Work Commission has to take into account these factors. Was there a valid reason for dismissal relating to capacity or conduct? Was the person notified of the reason? Was the person given an opportunity to respond to the reason? Any unreasonable refusal by the employer to allow the employee to have a support person present in discussions relating to the dismissal? Was the person given warnings prior to the dismissal if about unsatisfactory performance? How the size of the employer impacted its dismissal procedures? If the employer's business had a dedicated human resources specialist? And my favourite one, any other matters the Fair Work Commission considers relevant. So a dismissal may be harsh because of its consequences for the person, consequences for the personal and economic situation of the employee, or because it is disproportionate to the gravity of the alleged offence, or unjust because the employee was not guilty of the alleged offence on which the employer acted, or unreasonable because it was decided on inferences that would not reasonably have been drawn from the material before the employer, or that termination was disproportionate in the circumstances. So it only has to be one, harsh, unjust or unreasonable. So sometimes a dismissal may be harsh but not unjust or unreasonable, or it may be unjust but not harsh or unreasonable, or it may be unreasonable but not harsh or unjust. In many cases, the concepts will overlap. All right, so only for the purpose of our webinar today, only national system employees can make an unfair dismissal claim under the Fair Work Act, meaning that state government and local government employees, i.e. council employees in Queensland, can't make a claim unless they're potentially covered by a registered collective or enterprise agreement in the national system. Otherwise, they would likely have rights to challenge their dismissal under the Queensland Industrial Relations Act. But I'm not going to look at that today due to our time restrictions. Now, the Small Business Fair Dismissal Code, basically it provides a bit of leeway for small businesses around their procedures. I'll let you have a look at that slide there. But ultimately, it doesn't excuse small business employers from unfair dismissal claims. Now, a small business employer is a business with 14 or less employees, including employees of associated entities. Associated entities is defined under section 50 A of the Corporations Act. It's quite complicated, but basically a common example would be where there's a parent subsidiary arrangement, though all those employees could be counted in that situation. So where the parent owns shares in the subsidiary and owns enough shares to be able to control the makeup of the board, that's essentially the gist of it. It's about control. So it's not a complete defence for employers, and as the employer found out in the next case, another recent decision, in simple terms, this employee ran out of sick leave and they're on leave unpaid. I don't think that's necessarily a valid reason for dismissal, but anyway, they were dismissed, and the Commission found that the employee was not given adequate reasons for the termination of their employment at the time. She was dismissed, and so she was successful in her unfair dismissal claim. Now, genuine redundancy, this is very important. It's very important because if the Commission finds that an employee's dismissal is because of a genuine redundancy, it is a complete defence to unfair dismissal. The Fair Work Commission cannot look behind the genuine redundancy to say that, oh, but this person was selected for a discriminatory reason, or they were selected for poor performance without giving any warnings about it. It's a complete defence. So genuine redundancy occurs where the job is no longer required to be done by anyone. It's not reasonable for the person to be redeployed, and the employer consulted with the employee as required under a modern award or enterprise agreement. Sometimes the Commission will find that the position is no longer being required to be done, and it wasn't reasonable to redeploy the person, but they find that there's been a lack of consultation in accordance with the relevant modern award or enterprise agreement. In those cases, the Commission's formed the view that it will usually order 2 weeks compensation only, being the amount of time it would have taken to consult properly in accordance with the modern award or enterprise agreement. Very rarely, as an exception, the Fair Work Commission will find that if the employee was consulted with properly, they either wouldn't have been, their position wouldn't have been made redundant, or they would have been redeployed. And then the employee's in the game for potentially maximum compensation and or reinstatement. This is a case here that explains how the Fair Work Commission deals with the 3 limbs of genuine redundancy. Basically, in this case, in a nutshell, the person's position was made redundant. There was a job going in Sydney. They didn't, and she was in Perth. They didn't, I think, and she was in Perth, and they didn't offer it to her. And so she said that was not a genuine redundancy because they needed to offer her that job because she was had the skills and abilities to do it. And Commissioner Williams looked at the 3 elements. So turning to the first element, her position became redundant because her duties were divvied up amongst existing staff. So although her duties are being done, her job has gone because her duties are being done by as part of other jobs. So he was satisfied that the position was no longer required to be done by anyone. The Commissioner found that the employer consulted as required under the relevant modern award. And in relation to the 3rd limb about redeployment, the Commissioner found that it was not reasonable to redeploy the employee within the employee's enterprise because the employee said that she didn't want to go to Sydney. So even though the employer didn't offer her the job, the Commission found it was not reasonable to redeploy her, probably on the employer's own evidence that she didn't want to go to Sydney. All right, so the good thing about unfair dismissal is just about anything can be an unfair dismissal. There's been some pretty interesting cases where people have engaged in, employees have engaged in sexual harassment, theft, and it's still been found to be an unfair dismissal. The problem with unfair dismissal is that there's very strict eligibility requirements and the remedies are quite limited. All right, so just looking at these pretty briefly, the person must be an employee, so not a contractor, and a termination must be the employer's initiative. They have to be under the high income threshold, which is 145,400, unless still covered by a modern award or enterprise agreement. Note, remuneration in the form of a car, phone, other device, even insurance can be counted when assessing remuneration for the purpose of the high income threshold. Doesn't usually bother us community lawyers with our clients, but occasionally at JobWatch we'll get a call from someone who we have to talk to them about that on our TIS, including from Queensland. There's a minimum employment period. If it's a small business, 14 or less, including employees of associated entities, they have to be there for at least 12 months, continuous service. Other employers, only 6 months. Casual employees are eligible if they are regular and systematic with a reasonable expectation of that arrangement continuing. And something that's becoming more common, it should be noted that finishing up employment at the end of a fixed term contract or a maximum term contract with an agreed end date is not usually a termination at the employer's initiative. It's a termination due to the passage or the effluxion of time. But there's been cases recently where fixed term contracts, 6 month, 12 month, 3 month even contracts have just been rolled over several times, and that's just become the expectation. When the employer finally doesn't renew that fixed term contract that's been rolled over several times, the Commission has been willing to find lately that that is a termination at the employer's initiative. And the remedies are limited. So reinstatement and back pay, but out of about 14,000 unfair dismissal claims per year, there's only ever about 10 reinstatements. And compensation is capped at maximum 6 months lost wages. And there's a formula to work that out, which I won't go into, but basically the Commission has to work out how long the employee would have worked there but for the unfair dismissal. So sometimes, such as where there is serious misconduct but a lack of procedural fairness, the Commission might say that the person would have only worked for another month or something like that. So sometimes the remedies in unfair dismissal are quite low, and it's therefore best to try to resolve these matters at conciliation. Looking at the time, we're not going, we're about halfway through with not long to go. So we'll finish up after constructive dismissal and see if there's any questions. So an unfair dismissal or general protections termination claim may include an argument that there was a constructive dismissal. Constructive dismissal occurs when an employee is forced to resign because of the conduct of their employer. For example, an employee's work environment becomes so untenable they have no other reasonable option but to leave. It's not a separate claim. It has to be argued as part of unfair dismissal or general protections to say that they are the termination was at the employer's initiative. This is quite a high threshold usually, and so evidence is crucial. Examples might include where the employer breaches the employee's contract. If it's a significant breach that goes to the heart of the contract, the employer is repudiating the contract, the employee can say that's at an end at the employer's initiative. Bullying, sexual harassment, where they have no other option but to leave. and commonly an ultimatum given by the employer to resign or be sacked is also usually a constructive dismissal if that comes out in the evidence. So, being able to show the employer's conduct gave the employee no other reasonable option but to leave the employment, or in other words, that the action of the employer was the principal contributing factor which led to the termination of the employment relationship, then there will be a finding of constructive dismissal. In that case there, Mohad Zab and Dick Smith Electronics, in this case, the employee was given an ultimatum to resign or the police will be called, which the Commission found that was enough for finding of constructive dismissal. And there are some other examples there of what's been found to be a constructive dismissal. I'll just skip through these, keeping diary notes, etc. Evidence is crucial. Best not to use the words "I resign," but that's not fatal either. It's really a question of fact. Saying "I resign" is not fatal, but to be avoided because it on the face of it can look like a voluntary redundancy. And this is a recent case where there was a finding of constructive dismissal. The employer did a lot of unwise things in this little matter, but basically the employee was escorted off the premises without knowing why, and she thought that she was dismissed or going to be dismissed because she took a present from one of the residents she was looking after, and therefore she sent in her resignation, and the Commission found that although she sent in her resignation, the principal contributing factor to resignation was the conduct of the employer, so it was found to be a termination at the employer's initiative. Now, Carly, I'm just wondering, is there any questions out there, or do you want me to keep going?
Hi, Ian. Thank you. Yeah. So looks like we are about halfway through. There have been some questions that have come through, so maybe this is a good opportunity to deal with those questions now.
I'm happy to do that. I'm happy to say, at the end of the slides, everybody, there's the JobWatch administration number, and happy to give me a call or one of the other lawyers anytime to discuss your matters you're working on, or do a secondary consultation. So yeah, we're here to help as far as we can, so that's fine. But now, if there's any questions, that'd be great.
All right, no problems. So the first question that's come through from Chrissy is: do you receive inquiries about sham contracting?
Yes, of course. It's an increasing problem. We've got. I was going to deal with this later on in the slides, so if you want to have a look towards the end, I bring up a case called On-Call Interpreters and the Taxation Office, which looks at one way to try to work out whether the client is really an employee or a contractor. So in that case, Justice Blomberg tried to put together a two-limb test. So normally we have like an 8 indicator test, which looks at who has the right to control the manner and system of the person's work. Do they invoice? Do they have an ABN? Do they use their own tools or the employer's tools? Do they have the right to delegate? This test looks at basically, boil it right down, and it's at slide 71. The real question is the worker genuinely in business for themselves, i.e. carrying some risk, or are they an emanation of the employer? Now, the thing we always have to say occasionally in these things is each case does turn on its own facts. And of course, there's the sham contracting provisions in the general protections, which makes things like dismissing an employee to hire them as a contractor, that's unlawful, and representing an employment relationship as a contractor relationship, that's unlawful too, and the Fair Work Ombudsman and the federal can deal with that, or the Federal Circuit Court or Federal Court can penalise the employer. But yes, but often what happens with these cases is the situation is going along quite well. The contractor who is the employee who's on the person who's engaged or set up as a contractor, who's probably really an employee, doesn't really make any complaints. It's only when they find out they might be being underpaid or they're dismissed and they contact JobWatch, and if they're eligible, they can make an unfair dismissal claim. There might be a jurisdictional hearing to work out whether they're an employee or a contractor, and then they can pursue underpayment of wages as well. You can't contract out of the minimum wage, so let's say they became a cleaner and they were invoicing at $10 an hour, where the cleaning award is more like 21 for a permanent, something like that. They can recover all those things later. So yes, we deal with that on our info line, and we have a lot of clients like that as well. So if you've got any questions around those things, please don't hesitate to call. Thank you for the question.
Great. We've got another one that's come through, Ian, from Roxanne. Are you aware of any or many cases where independent contractors have successfully pursued superannuation entitlements? It seems many clients of ours are unaware that even as an independent contractor, they may be entitled to be paid superannuation. Thanks, Roxanne.
Yes, thank you, Roxanne. Yes, that's a good point. I often have conversations with employers/principals where at one point it will come to, well, look, even if you're right and you're saying that they're an independent contractor, you still have to pay them super, you know. So under the superannuation guarantee legislation, if a contractor supplies their labour to one principal 80% or more of the time, they're still entitled to superannuation. So often that's a good way to try to resolve those matters, because the principal/employer is going to lose the case anyway. Problem is that's an ATO complaint, and not that quick at taking these things up. But yes, with superannuation, so if that contractor is really at law an employee, let's say they're a cleaner, for example, well then under the Cleaning Services Award, there's a superannuation provision which says the employer must pay superannuation, so that can be dealt with as an underpayment claim in the Federal Circuit Court. And any other underpayments can be added in there. Off the top of my head, I don't know of any particular cases where, apart from the one I put in the webinar, yes, the on-call interpreters there at slide 71, I think it is, they were found to be employees. I think they wore the uniform of the translating agency, and they were directed by them to attend the jobs and things like that. So have a look at that case. That's one of the more recent cases, and it's a good case in the sense that it tries to sort of simplify, if you like, that indicator test, that really none of the indicators are determinative, and even if you add up, more than 51% looks like an employee, one on the other side, like using your own tools, could tip it to say no, well, but use your own tools, so you're a contractor. So yes, so that on-call interpreter case is 2011, but it's fairly recent. And then you're going back to old High Court cases of Hollis and Barbu, where the courier driver was found to be an employee. Those sorts of cases. Thank you. Any other questions, Carly?
Yeah, we've got a few that are just sort of more related to, actually, I might do this one first. So this one is related to bullying. So the question was, what's the threshold for the Fair Work definition of bullying? And if you could provide some examples of cases where it was ruled to have happened versus cases where there wasn't enough evidence or strong enough argument to demonstrate bullying. I think you did cover that a little bit, but if you've got anything else you wanted to say around that point, that would be great.
Yeah, we'll cover that a little bit. I haven't got any other cases that I put in the webinar today. I think with stop bullying order applications generally, the applicant has nothing to lose. They file their application, it goes to conciliation. Maybe it settles at that stage, depending on what they want. Do they want to negotiate an exit package, if you like, a payment to resign, or do they genuinely want to stay there and negotiate? Look, I can't work with this person anymore. Can I have a new person to report to? Or can I not be in the room alone with this person? Can I have someone with me at my performance reviews? Something like that. But it's one of the problems I have had is reasonable management action carried out in a reasonable manner. Reasonable is not a very high bar. Okay? It's quite easy for the employer to satisfy that if the employee is complaining about, I don't know, excessive performance reviews and being told off for being late or having too long a breaks when no one else is. That's not the question. The question is the conduct directed towards you reasonable management action or not? I remember one of the first cases, and I can't remember the name off the top of my head, one of the first cases that a stop bullying order was made in, and I believe it might have been a law firm, and there were two employees, I think they were both women, who would arrive at work in the lift at about the same time, and they were making unreasonable comments about each other's appearance and dress sense and things like that. And I think they may have both made stop bullying orders, so it's not common, made applications, so it's not uncommon to get cross-bullying claims. And in that case, the Commission made orders that one of them arrive at 8:45 and the other one arrive at 9:15, and that solved the problem. So yes, but when in Victoria, prior to the stop bullying order provisions coming into force in the Fair Work Act, our WorkSafe received 8,000 calls in 1 year about bullying, and we thought that this would be a game changer. It would take off, and there'd be tens of thousands of applications to the Fair Work Commission. But I think in its first year, which was I think 2014, there were only 300 applications Australia-wide, I think. If you've ever had a look at the form, it's quite comprehensive in the sense that you've got to put down your witnesses in that form, which obviously is going to put a lot of people off because of potential sort of witness tampering, if you like, and getting their co-workers in trouble. So yeah, it's a bit of a daunting process, but what I always say, especially even if the person's not, even if we're not confident that the person's working at a constitutionally covered business, and I know there was just a decision recently where a government department in New South Wales was held to be a constitutionally covered business because 3% of its income was from some sort of commercial venture. So that's not a high bar either. But even if we're not confident that the person's working in a constitutionally covered business, my advice is to file the stop bullying order, and it would usually be listed for conciliation first anyway. And ultimately, if it goes to a jurisdictional hearing and the Commission throws it out, well, that's been thrown out and sort of no worse off really in that sense.
Great.
Thanks, Kylie. Any other ones?
Thank you. Yes, we do have a question from Shungu from the Consumer Action Law Centre. So this is really, I think, a really common issue, potentially. So he's asked, does working when on a visa without a right to work exclude those people from these provisions?
That's a good question. And JobWatch has actually just run a case and we're waiting on the decision. In that case, the employer alleged that our client worked outside her student visa 20 hours a week work rights, and they stood her down because of that, and then didn't pay her, and then did nothing, and then we alleged that she was constructively dismissed. So the outcome of that case will be shed some light on this question, but as we're speaking right now, the answer is if the person doesn't have work rights, then they're not entitled to be paid, and they're not entitled to make an unfair dismissal claim, for example, because their contract of employment is unlawful. Okay, there is a case that the name escapes me right now, but the person was working under a 457 visa where the employer is the sponsor, and they got a new job with a new employer, but they never got sponsored by that employer. So after a period of time, maybe a year or two, they were dismissed by the second employer who wasn't the sponsor, and they made an unfair dismissal claim. And part of the finding in that case was that the employee was not entitled to work because they didn't have a valid visa, and therefore they were not entitled to make an unfair dismissal claim because their contract of employment could not be enforced. So following on from that, if a visa worker, let's say a student visa worker who's allowed 20 hours and they're being underpaid, but if they claim their underpayments, they may not be able to claim their underpayments for the hours they've worked in excess of their visa because they don't have work rights. That's pretty harsh, but I think that's the correct interpretation of the visa intersection with the Fair Work Act and the common law contract of employment. It's a bit like, if you think about it, it's a bit like what we all learned at university in contract law. You can't enforce an illegal contract, you know, for a hitman or something like that. So that's where you've got to take the cues from. Yes, so harsh, but that's the legal reality, I think.
Okay. There has been one more question come through, and I do have a couple of other just general questions. So perhaps, Ian, if we could deal with this one quite quickly, because I'm aware that we're a little bit over time and people may need to go. Yeah. If you could briefly explain your experience with the ATO regarding unpaid superannuation. So what Chrissy is just asking or mentioning that in one instance the ATO did not respond at all. Is that usual, or would that be quite a rare circumstance?
Yes, well, without sort of being too critical of the ATO, due to their funding allocation to this section, etc., I don't bother for a client going to the ATO. On our telephone information service, the tailored legal information would tell our caller that that's an option for them. That's one of the options. But for a client, so long as they had a modern award, which they usually do, because that covers the usual, you know, Jack and Jill jobs, retail, cleaning, hospitality, etc. The judges in the Federal Circuit Court are usually willing to make an order for unpaid super based on the standing or right to be paid super under the relevant modern award. So I just take that course of action. The Fair Work Ombudsman's not interested in recovering super. They don't worry about that either. Yes, that's the answer.
All right, thank you. So before we wrap up, and I'm sure you've got this in your conclusion, but if you could just let us know for our Queensland listeners, what is the scope of the assistance that JobWatch can provide to Queensland employees, and are there any situations, and what are those, where the clients might be referred back to Queensland CLCs?
Yes, well, as we said at the start, so our telephone information service provides tailored legal information and can deal with any and all work-related questions. So They don't have to be an employee. They don't have to be a national system employee. Any and all work-related questions can be dealt with on our telephone information service, but it's tailored legal information as opposed to strict legal advice. So our legal practice is not funded to represent Queensland workers, and I haven't got to the bottom of even whether we could due to practice certificate issues, etc. Although most of the issues are in the federal jurisdiction, so that's possible, but I don't know the answer off the top of my head right now. So yes, we give people a list of relevant referrals, including the community sector up there, where you are, the Queensland Legal Aid, the Queensland Law Society, and anything else we can think of that's relevant to their particular case. So if people are looking for referrals, then don't hesitate to contact us, email us. But what needs to be remembered is our telephone information service is open to all workers in Victoria, Queensland, and Tasmania. Only really a small proportion of those, I don't know what the percentage would be off the top of my head, but only a smallish proportion of those would be suitable community legal centre clients. So, yes, so that's the answer, Carly.
Thank you. That's great. Okay, well, we might wrap things up there. Apologies for not being able to get to the rest of the content, but perhaps we can, if there are any listeners out there who have a specific question regarding to some of the content that is contained in the PowerPoints, you can get in touch with us or directly in contact with JobWatch. But for now, oh, sorry, Ian. Yep.
No, sorry, I was just going to say our admin number is at the end of the slides, and please don't hesitate to call. That'd be great. We'd love to hear from you.
Wonderful. All right. Well, thank you so much on behalf of everyone listening today to Ian and Zana for donating your time to provide some really great information around anti-discrimination, bullying, unfair dismissal and constructive dismissal, and thanks for answering all those questions that came through. Certainly is a big area of law for our centres up here and workers across the country, so thank you for that. And we'll send the PowerPoints, the recording for today's webinar and contact details for JobWatch out tomorrow to everyone who's registered. So thank you again, and we'll see you next time.
Thank you very much, Carly. Thank you, everyone.